Judge Florentino Floro Jr., who filed a petition in intervention on post-disqualification case, claims respondents and even the amici curiae, or friends of court, failed to discuss the Convention on the Rights to Children, a treaty ratified by the Senate in 1990 and part of the law of the land. Floro points out under the treaty, any Filipino, legitimate or illegitimate, is granted absolute political right, especially rights to citizenship. He now joins us in the studio to further explain this to us. Judge Florentino Floro Jr., good afternoon to you, sir.
Good afternoon, ma'am.
All right, so pinanood niyo po yung oral arguments dun po sa Supreme Court.
Yes, the oral argument started 1:15 p.m. and it finished 1:30 a.m.
Opo. And all throughout that, for the most part, you were there?
Yes, for the most part, I was not able to watch the two amici curiae, Magallona and Balane, but I watched all the arguments.
You're saying, though, that in essence, you filed what you call a petition in intervention on post-disqualification case. In layman's terms po, sir, petition in intervention is what?
Is a petition filed under the rules of court wherein a party who has a direct or special interest may be allowed to file pleadings and be part of the case because of his rights that may be affected.
Even if you're not associated probably to either side. So an ordinary Filipino can actually file a motion for intervention.
Yes, any registered voter, citizen, and taxpayer, like the petitioners in this case, they are main petitioners to disqualify FPJ. But under the rules of court, since I'm not asking for the disqualification, but for the qualification in favor of FPJ, the right petition is a petition in intervention.
Okay, so that's what you have filed. But you said you had a clause there saying that you have the right to file a petition for intervention just as long as it will not affect, ano po?
Under the rules of court, I have the right as a registered voter, a taxpayer, and a citizen to file a petition for intervention in this case. Especially, I have a direct interest in this case because the outcome of this case, which is of paramount character and interest, will affect not only the Filipinos, but I myself.
All right. Your basic defense or the argument that you want to put forward is what you call the Convention on the Rights of the Child, or CRC. And you're saying that all friends of court did not bring in this particular argument.
Not only the friends of court, but the petitioners and even respondent po, through his counsels, never touched on this matter, which was, this matter was repeatedly taken by the Supreme Court Justice Puno in his questions. Okay.
Tell us more about the Convention on the Rights of the Child then.
The Convention on the Rights of the Child, this is a treaty adopted by the UN Assembly in 1989, which entered into force on September 2, 1990, and the Philippines became the 31st state to ratify this CRC, or Convention on the Rights of the Child, in July 1990, by virtue of Senate Resolution number 109. This treaty has the force and effect of law in the Philippines and in other countries. Now, the reason is that under our laws, a treaty that's ratified by the Senate in accordance with Section 21 of Article 7 of the Constitution has the force and effect of law. Now, it is very clear that this treaty, the CRC, unlike other international human rights instruments, affords complete and comprehensive rights for children. Under this treaty, children, Filipinos or foreign, like respondent po in 1939 or 1940, to be exact, the 20th August, are granted protection rights, like rights to nationality. And this is unqualified. This is the anchor and the legal ground that supports the petition, the stance of respondent po through his lawyers Mendoza and Brillantes. And this was not included, but this was tackled in the questions, several questions thrown by Supreme Court Justice Puno to the amici curiae and to the other petitioners.
But you're saying that Justice Puno was throwing this question, but it wasn't really further discussed by either the defense or the petitioners.
Not only
And the
further
friends of
discussed,
court.
but this law was never pleaded in their pleadings.
Opo, all right. Of course, when we say the CRC or the Convention on the Rights of the Child, this pleading must have been included by the defense in order to protect FPJ. Because what you're saying is, if we look at the Convention on the Rights of the Child, that will allow FPJ to actually be a natural-born Filipino. Ano po?
Yes, madam.
Okay, so ibig sabihin nga, parang what you're trying to say is that pwede sanang nasama ng defense counsels ni FPJ itong CRC.
Yes, it must have been included because this is the heart of the matter. Because if you read the newspaper summary of the oral argument, you can, by a cursory perusal thereof, none of the petition or the pleadings filed definitely included this Convention on the Rights of the Child,
Opo.
which is the principal basis that
So it's really the rights of the child.
convention.
And to be very specific, it says that under this treaty, before we say a treaty, can we actually consider a treaty a law? What if medyo salungat po ito sa certain provisions within the Constitution? Does this take effect?
No, it is expressly provided under the Constitution that a treaty, international treaty like this, when ratified by the Senate,
Opo.
becomes part of the law of the land.
And it was ratified by the
Yes,
Senate.
we became the
1991.
31st country
Opo.
to have ratified this on July 1990, specifically by Senate Resolution 109.
Okay. You're saying that under this treaty, children, Filipinos or foreign, so mga bata, whether Filipino o dayuhan, are granted protection rights like the right to nationality.
Irrespective of whether they are legitimate or legitimate,
Opo.
that is the position of the amici curiae.
Okay. So, but what exactly does it mean that they are granted protection rights like right to nationality? Anong ibig sabihin nun?
Of course, not only nationality, but even mentally retarded children are given rights to study and other protection rights. But in this case, I want to stress that the political right being granted that is unqualified and very clear under our law, this treaty, part of law of the land, is the right to nationality, meaning the right to Filipino citizenship. Not only that, but natural-born Filipino citizenship.
Does that necessarily follow pagka sinabing Filipino, natural-born Filipino? First of all, let's himayin po natin, ano po ang ibig sabihin ng right to nationality? What does that mean because of this treaty? So, all children born in the Philippines, kailangan ba born in the Philippines?
No, we follow the jus sanguinis.
What is that, sir?
The law of the blood, meaning those born in the Philippines, those of
place of birth, hindi ba?
No, yeah. Those jus sanguinis means those children born of the parents, Filipino parents, father or mother, are Filipino. Of course, there are ramifications under the Constitution, settled jurisprudence, and that is what they are tackling. But our position is that we support the amici curiae's positions and argument that in case of hard interpretations or several conflict of interpretations in the law, there must be a liberal construction of the law, meaning we suggest a Solomonic solution to the FEJ disqualification case, an interpretation that will promote public welfare and policy that will be conducive to the state in favor of the child, of course, must be taken into consideration by the court. That interpretation, liberal construction.
Liberal was somehow what was described with the arguments, the oral arguments of the four amici curiaes.
The amici curiae is specifically through the matter of deciding whether the court should decide the case liberally or strictly.